After tree break, we have gathered together now, and this being the last session, everybody is happy. Everybody will be free after 2 days. And today's subject is transitional issues and way forward. And our speaker is Ratan Samalji, Advocate Ratan Samalji. Now I request Mr. Praveen Shinde to introduce Ratan Samalji. Praveen Shinde, please.
Good evening. Respected President Dr. Shashank Don, office bearers, dignitaries on the dais, of the dais. I would like to introduce last technical session speaker, Advocate Sri Ratan Samal sir. His area of practice including both direct and indirect taxes. He regularly appears before Maharashtra Sales Tax Tribunal, Income Tax Appellate Tribunal and Bombay High Court. He is practicing since last 26 years. He has achieved number of awards for the outstanding performance in lectures, seminars, writs, etc. He also achieved success in filing various PIL including educational matter to the needy children. At present, he is the president of Sales Tax Tribunal Bar Association. He will deliver lecture on the subject transaction issue and way forward. With this short introduction, I request all of you to welcome sir with big hands. On behalf of STPM, I request our President Dr. Shashank Don to offer him memento as a love and respect. Thank you.
Respected President and other office bearers, my senior and my friends. Today I have been given a chance to deliver the last lecture, which is in fact the transitional provision in fact is a subject of khichdi, but at the same time it is utmost important for all of us, whether they are practicing in the excise law or sales tax law or in the service tax law. Mainly I am focusing on these three subjects. Now the transitional provision means we are leaving somebody and taking the others. That period is a crucial period. We are adapting something new. As you may not agree that is a new, because my friend Kiran Garkar has already said that nothing is new. In fact, it is a khichdi of three subjects. Now, so far as this transitional aspect is concerned, again, is not a new subject for us. We have already studied this aspect. We call under the earlier laws, if you take the example of Bombay Sales Tax Act or VAT Act, we have the provisions. We called in a different manner, that is this saving clause, which we call saving provision. At present under the VAT law, section 96 speaks about these aspects. So what are the saving aspects? So saving aspects, before coming, I will have to explain 1 minute historical background of these saving aspects. We should not forget our basic aspects, that is the general clause provisions. Why I am pointing out this aspect? It has utmost importance while interpreting the provisions of these saving aspects, that is a transitional aspect. Under the general clause law, General Clause Act is such an act which says wherever you will not find any meaning, wherever no meaning is provided under any statutes, then you have to adopt that general clause. So it is nonetheless a mother law, in fact, after constitutions. So in the General Clause Act, you will find some saving aspects. Now, we do not have any mechanism in any statute, in any law, about the saving aspects. So far as the legality aspect is concerned, so far as the mechanism is concerned, they are providing. I will come in the little course while explaining the provisions. So far as the mechanism is concerned, you will read and understand the things. So no doubt about it. But what is the important, utmost important? I will give an illustration way. Thereafter I will come directly to this topic. It will not take much more 15 minutes time. But understanding of this saving aspect, the transactional aspect is most important. In the VAT regime you will find that we have came from the Bombay sales, earlier Bombay sales tax was there. So that was the point, last point taxation in fact. Now thereafter each and every point taxation we have entered in 2005. Now when we have entered, I will give an example only. Say under the Bombay sales tax law, a provision was there that an assessment is required to be made within a period of 3 years if the returns are filed within the prescribed time. Now when they brought this VAT regime, when we entered into the VAT regime, under the VAT enactment, they made some sort of provisions under the VAT legislation that an assessment, even if completed within a period of 5 years, then it will be deemed to be treated as a proper assessment. So we have bypassed that old enactment, and in the saving provision we have added such sort of provision, that is saving provision, saying that even if it is a 5 years, then also the assessment can be treated as a well and good. Now the question arises herein, whether under this repealed law, when provision was not there at all, in the new enactment, can you make such sort of provisions to safeguard the interest of the government? Now, in the Bombay Sales Tax Act 3 years, I will not take much more time in order to explain this aspect only. Bombay Sales Tax Act 3-year provision was there for completing an assessment, repealed. In the new enactment in the section 96, you are introducing that 5 years you have to bring. Now, if you read the general clause provisions, because the transactional provision when you read, then general clause you should not forget. So far the principal party is concerned. So if any mechanism you are bringing, which is absolutely contrary, a counter to that old enactment, the general clause act says no, that will be treated as a invalid aspects. So keeping in mind this aspect only, we will have to go into the subjects. So what was the old mechanism? For example, when we say a study about the continuous works contract, if you will see under here also such sort of mechanism is there. That's why I am pointing out these aspects in order to make it a little bit clear to the subjects. Under the works contract law, prior to the VAT enactment, you will find that some sort of mechanism was there as far the composition scheme is concerned, or rate of tax is concerned. Now such sort of saving has been given in the value added taxation system. Now if you will read, so far as the works contract is concerned, so wherever the continuous works contract is there, works contract is continuing, you have entered a contract prior to the VAT regime, and thereafter you are coming to the VAT regime, they made some sort of a mechanism that the old law should not be disturbed. You have to go with that, because the basic aspect of entering into the contract, you have made in the Bombay Sales Tax a works contract regime, though you have entered in the VAT regime, but that law which was prevailing at the time of entering into the contract should be treated as valid and it should prevail. No, such sort of mechanism is absent here. That's the whole idea in pointing out this aspect, because the 96 provisions which they made earlier under the old regime, There, as I pointed out, so far as this time bar provision is concerned, it is contrary to the General Clause Act. So far as this works contract aspect is concerned, in the transitional base, they have safeguarded that one. So that is a pure, valid and in consonance with the General Clause Act. Now, keeping in mind these aspects, let us go to this model bylaw, what they are, so far the transactional provision is concerned, what they are saying in these aspects. Whether it is in consonance with these aspects or not in consonance with the General Clause aspects. We have to see, and on that basis we have to frame our mind which is correct and which is not correct, and on this basis we have to move. Now, so far as first transitional provision is concerned in the model bylaws, the officer will remain same. Now, since last 2 days you have completed the entire this model bylaws, these officers will continue. Now, the local sales tax officer who have appointed by the authorities, by the state authorities, they will hold the post of the sales tax officer. Under the GST also they will be the officer. Similar with the central government, those who have appointed the authorities, they will be also remain as the officers for the purpose of executing this GST. Now, keeping in this mind, the central government has recruited, that is the report from the news agencies, a high number of officers they have appointed so far as this part is concerned. Keeping in mind. Now, what will be about the implementations of our local law, we will have to keep in mind because it has been narrowed down. That means the central, we have to appear sometimes before the central agencies as well as before the state agencies, but the state agencies role may be a little bit lower than the central agency. Central agency will prevail, it appears, from this particular provisions because those officers will remain as it is for the purpose of this executing this, administrating and implementing this. That is not much more important. Now, so far as the migration of existing taxpayers to the GST, within 6 months, immediately after implication of this particular law, immediately after this act is enacted, then a particular number, the registration topic he must have discussed, who has taken this registration topic, madam might have discussed all these aspects. Automatically a registration number will be given and that will be valid for the period of 6 months. And within the period of that 6 months, you have to comply certain formalities. And if you comply these formalities, whatever the procedure laid down for this purpose under the rule, then you will given a final registration certificate under both SGST and CGST. If you are unable to comply, then in such circumstances, you will be deemed to be treated as unregistered. Though for that purpose, show cause and all these processes they may follow. So in this transitional period, some of the friends are there saying that we will be out immediately after this implementation of this GST law. That is not so. Because once within 6 months you have to make certain compliances procedures. So you will be there. And not only here, you will have to comply the procedures under the service tax and the GST, those formalities also you have to comply here. So you will be there. So within 6 months, if you are unable to comply, then the show cause notice will be issued by the authorities and we have to comply that. So in between the transactional period, so the registration, that means temporary registration and final registrations period, then lot of formalities and procedures are there. So immediately after this act is enacted, you will get a temporary number. After within that period, within 6 months, after compliance of all these details, then you will get a final registration certificate under the either SGST or GST Act. So that is the transactional aspect involved so far as the registration is concerned. Now, second aspect is concerned. Carry forward returns. again set off a SENVAT, a input tax credit, which is carry forwarded in the return. In the month of March or February, in last quarter, last 6 months, last month, you have carry forwarded the refunds, because certain refund mechanism, I think refund mechanism also we have discussed here, I think, madam, I think you have discussed all these refund aspects. Now, so far as this carry forward, because since we are practicing under the Maharashtra Value Added Tax Act, we are little bit conservative approach so far as the carry forward part is concerned. But in other states, various states, they have the mechanism of carry forward into the next year. So here some limit is given under the VAT regime. Some 5 lakh, earlier it was 1 lakh, all these provisions were. But in other states, some of the mechanisms are there in other value addition taxes in other states like Calcutta, Tamil Nadu. If you take into consideration, they have the carry forward mechanism there available, instead of immediately granting refund in that particular year from 1 year to another year. So keeping in view all these aspects throughout India, they said that wherever the return source carry forward in the earlier tax laws, that is VAT or GST or VAT or excise or service tax, whatever the name may be called, then in such circumstances, immediately after the appointed day, that stock which has been given the credit is admissible as a SENVAT credit so far as the central excise is concerned, or the service tax is concerned, or so far as our local law is concerned, sales tax, VAT is concerned, we are entitled the benefit of that, whatever the credit has been given, irrespective of other factors. So non-ostensible clause starts in the general provisions, therefore with irrespective of other facts, whatever that carry forwarded, you are entitled the benefit, but subject to one particular aspects. If that carry forward is wrong, you are not entitled at all, but wrongly claimed. For that purpose, in the model bylaws, they have given by way of a proviso. This is that if carry forward ultimately found to be wrong, say after 3 years, then in such circumstances, you have to pay directly as if it is an arrears of tax. Since for the month of March, last quarter, last 6 months you have adjusted here, if you take in the VAT concept, and after 6 months, 1 year you found that, no, this credit is not available because of 48.5, say for example, that vendor has not deposited tax into treasury. But on the basis of tax invoices, you have claimed in the return and carry forwarded it. Then in such circumstances, you have already adjusted in the month of April, keeping in mind this transitional provisions. Then in such circumstances, you have to pay, that will not be disturbed. I mean that return position in the April month's return, that will not be discharged. You are entitled, but at the same time, when the authority founds that wrongly claimed, this input tax credit wrongly claimed and carry forwarded, if it is established, then in such circumstances you have to pay as if it is an arrears of tax. So, both under the CGST and the SGST, such mechanism they have made in this so far as the transactional aspect is concerned. Now, so far as the capital goods also concerned, under the central excise it has a greater impact, so far as the capital goods is concerned, SENVAT. Even under the service tax is also there greater impact. Here also we used to take a capital goods benefit as an input tax credit. So whatever the capital goods brought in the earlier law and the input tax credit remains to be utilized, either you have carry forwarded or not taken as a refund. We have to keep in mind the entire states, because there are so many states where carry forward aspects is available. So if you are not utilized that portions, then you can take the benefit in the month of April, May, June, whatever may be after the implementations of this law. That is, so far as the capital is concerned, it's written in very simple language. I am not going wherever important aspects, I will touch that aspects. Now, so far as the stocks is concerned, credit of eligibility duties and taxes in respect of inputs held in stock to be allowed in certain situations. Now, every time I am pointing at the situation where the authorities found subsequently that is not allowable at all. Now, allowable means here most important aspects, keep in mind, most important aspects. Either not allowable under the repealed law, that is old law, VAT, a central excise or service tax, finance act, either not allowable under those old laws, or if it is found not allowable under the current law. There the difficulty. That's why I pointed out the general clause. What they say is, if it founds that contrary to section 48.5, if you are taking VAT Act, contrary to section 48.5, then it is not allowable. But you are fitting into the parameter of section 48.5. But you are not coming under the parameter of the current enactment, that is SGST. Then also you are not eligible. That is that provision I found in incorrect provisions and contrary to the general clause aspects, so far as these transitional aspects. You are bringing a particular law, say for example from 1st April 2017, there you are giving some restrictions so far as the availability of input tax credit, which was not there at all under the old law maybe. So you are imposing a restrictions for availability, a carry forward of that refund of the earlier part, repealed law, and saying that if you are not eligible under the current law also, then also it will be deemed to be treated as not allowable. That portion I find and not in consonance with the general clause. We have to apply our mind so far as this part is concerned. So far as the 48.5 is concerned, earlier law, if you are not fitting, then not allowable, that is a different part. It can be collected as an arrears of tax. That's a different part. But so far as this is concerned, it is a very important aspects we have to keep in mind. Because the legislation which they are bringing, that is after first away. Even under the constitutional setup, ex posto facto law, that is section article 20 is there, an ex posto facto law. If you are bringing a particular law, applicability is from a particular date, then the transactions effected from that particular date will be taken into account, and that law governs to the transactions pertaining to that particular date only. Now we are bringing a new law. I am not talking about the retrospective legislation or retroactive legislation. What I am talking, an ex posto facto law, you are bringing a new law, but you are disallowing the transactions for the earlier period on the basis of a new law, which I find incorrect in this legislations. So we have to keep in mind these aspects. So it again ultra vires article 20 bracket 2. So far as the stock is also concerned, they are bringing some mechanism by way of rule that on a particular date you have to submit the details of the stocks which you are holding under the earlier enactment, either under the excise law or under this value added tax law. So whatever the stocks available, you have to submit, and if the tax has been paid on the stocks, then you are entitled the benefits. So they have classified into two parameters here. One as a manufacturer of goods, other is a sale of goods. So the manufactured stocks, if it is available on the last day, when you enter into this now new enactment, new law, you have to give the details of that stocks available with you as per the mechanism which they are going to provide, because we are studying now a model law. So on that basis, you are entitled the benefit of the tax paid under the earlier stock. And so far as the manufacturer is concerned, so far as the sale of goods is concerned, whatever the goods which you have, the trading goods, I mean, whatever the trading stocks on which the tax has been paid locally, then you are entitled the benefit of that stock subject to the provisions which they are going to incorporate by way of rules. Now, amount payable here, which in the beginning I have discussed, amount payable in the event of taxable person switching over to composition scheme. Now all these definitions you have, I mean, it is clear to you, taxable persons, non-taxable persons and everything, tax, supply of goods and everything, it is clear to you. Now where a taxable persons who carry forward the amount of eligible credit in the return furnished under the earlier law in respect of the period ending with the day immediate preceding the appointed day switches over to the composition scheme, then he shall pay an amount by debit in the elected credit ledger equivalent to the credit input tax in respect of the input held in the stocks. So he himself, by way of electronic register, you must have studied this electronic register concept also. So by way of electronic register, you have to take into accounts, so whatever the tax has been paid in your manufactured stock or in the trading stock, and you can take the benefit of that. And again, the restrictive clause that if you are not eligible either under the old laws, so far as the input tax credit rules are concerned, if you are not eligible, then you have to pay by way of arrears of tax. Now duty paid goods returned to the place of business on or after appointed way. Here the most important aspect is concerned.